Well, good morning, everyone. This is George Spees, former Chief of Outreach and Training with the Pennsylvania Office of Open Records, and welcome to this morning's webinar, where we're going to talk about the right to know law, but specifically as to how it applies to law enforcement and the law enforcement community. Essentially, there's a lot to learn about the right to know law. There's a lot of material in there, but we recognize that law enforcement, police department, and so forth have a lot on their plates already. And so what we've done is basically parsed out those areas of the right to know law that we feel would be useful to law enforcement to have a working understanding of. So that's what we're going to be focusing on here this morning. Let me go through a couple preliminaries just for the good of the order here. First, if you've not participated in one of these webinars before, essentially it's PowerPoint based. These PowerPoints that we use are available on the OOR's website. You would go over to the training tab and scroll down, and you can find all of the PowerPoints that we use for not only these webinars, but other training opportunities. And you're welcome to download those as you see fit. It may be that you have some colleagues who weren't available this morning, so maybe they'd like to take a look at it, perhaps for your own future reference, or maybe you're considering conducting some local training. So feel free to use the PowerPoints as a resource. Also, this session is being recorded. Typically what happens is that in a day or two, one of the admin staff will clean up the recording a little bit, load it to our YouTube channel, and then establish a link, again, back to the OOR's website. And it should be over on the training tab. Now, that usually takes a couple days, but again, feel free to review the recording as you deem necessary, perhaps a colleague who couldn't join, and again, maybe localized training or even using it for your own future reference. We view these as public records, so you're more than entitled and welcome to take a look at them. As far as today's session goes, you can ask questions using the chat feature, and I will do my best to answer them live. Now, we recognize that we have an issue with the chat. For whatever reason, it's not advancing, but I found that if I turn the chat off and turn the chat on, it then advances. So I think what we'll do is after each slide, I'll take a moment, just a second, and try to advance it. And then if there's any questions, I'll try and answer it at that point. Now, with the questions, I've got a favor to ask you, actually two favors. We're talking about the right to know law. So let's stay on topic and keep our questions germane to that. Also, it's very helpful if you can keep your questions as brief and succinct as possible. Occasionally, occasionally folks will type in several paragraphs, and honestly, it's just awkward for me to sit here and read through all of that while everyone else is waiting patiently. Look, if you have something that's unusually complex or specific to your situation, what we'll do is, well, we'll do one of two things. We'll either wait until the end, and I'll do my best to return to it, and we can answer it for the benefit of everyone, or we'll take the conversation offline. The contact information for the Office of Open Records is on the screen right now. And what would happen is, like, if you call in or send an email, it comes to the administrative staff, and they're pretty good with being able to answer your questions, get you steered in the right direction. Now, if you happen to stump the panel, your question will get escalated up to one of the senior managers. And for the most part, they're able to get back to you within 24 hours. We figure, if you've reached out to the Office of Open Records, it's something that's time sensitive and it's something that's important. So we like to get a quick turnaround there. Okay, so I think that takes care of all the preliminaries. Let's jump into the presentation here. And I want to begin by talking about, just why the right to know is important. And, I like to indicate that it's a matter of access to government records, transparency of government operations. It just represents good government. So let's put a fundamental statement out there that I'd like to start these presentations with. And it has to do with the purpose of the right to know law. What's this all about? Because quite honestly, there's a lot of misunderstanding. People see that phrase right to know, and they assume that, okay, this is some form of Google for government. And it's not. The right to know law is very specific in its purpose. It's to give the public access to public records. Okay, and the challenge here is figuring out what exactly is a public record. Okay, so your starting point is that every record that an agency has is presumed to be public. Okay, that's when you receive a right to know request. If you happen to be on the agency side of the equation here, that's the mindset that you have when this whole process starts. Everything we have is a public record. Okay, now suddenly that starts a panic. It's like, oh my gosh, you know, everything in the office here is going to end up on somebody's Facebook page or on the front page of the newspaper or whatever. And I'm here to tell you that that's not the case. You're going to discover as you become more familiar with the right to know law that the law itself, as well as other laws, particularly as it relates to law enforcement, has tools built into it that if you receive a request for a record and it raises a red flag and you're just thinking, I don't know, I'm just not comfortable with the idea of releasing this record into the public, it just doesn't seem right, there is a very good chance that one of these tools would allow you to withhold that record from disclosure into the public domain. And we're going to talk about some of that. We also have another webinar that we offer. It's called Laws That Protect Information, that goes into detail about other laws in addition to right to know that deem certain records as being confidential. Okay, now let's say that that red flag goes up and you're thinking, for whatever reason, I just don't think it's appropriate that we should release this record. The agency, meaning the department or wherever you might be from, if you're here representing an agency, has the legal burden of proving that the record is not public. You can't just say, I'm not comfortable with releasing this, so we're going to withhold it and we're going to deny your request. Rather, you have to make a legal case as to why you're not releasing that record. And while that is, the crux of the matter, while that is imperative, it's important, it's not necessarily that hard, okay? You just need to refer to the appropriate provision of the right law that makes your legal case for why you're not releasing the record, whether it be the right to know law or one of these other laws that deem certain records as being confidential. Okay, let me check the chat feature and see if we have anything here. Okay, looks like we don't have any questions yet. It's going to be a somewhat cumbersome exercise, but it looks like it's a good workaround. Okay, so we're going to assume that your agency is subject to the right to know law. There are some things that you have to do. First, and probably most important, is to appoint an agency open records officer, or someone also known as a right to know officer. The two terms are interchangeable. There's no difference. We call them arrows here at the Office of Open Records. Okay, now the arrow is the person responsible for receiving right to know requests, processing those requests, and then responding to those requests. There's nothing in the right to know law that limits who that person can be, other than saying it has to be either an employee or an official of the agency. So it could be an administrative person sitting at the front desk when you walk into the department's offices, or it could be the chief, or depending on the organization of your jurisdiction, it could be the mayor, it could be the chief of council, it could be one of the officers. It's up to you as to how you organize your open records program. Also, you can have more than one arrow. It just, again, it depends on the organization of your jurisdiction and how you want to do that. It is not uncommon to find, let's say we're working with a borough. that you would have one arrow handling the administrative side of the borough's operations, and then a separate arrow handling the law enforcement side. But you want to make sure that it's clear to the public if they come walking in with a right to know request, or if they want to file a right to know request, who do I give it to? So you're required to post contact information physically within your business offices, as well as if you have a website, that it would be on your website, all this information about the right to know law. Look at it from the public's perspective, okay? They don't really know what this law is all about. They just know that it exists and that they have a right to public records. So the more you can do to educate them before they come walking in the door or before they have questions, the better. Okay, it might be a little extra work on your part, but by educating the public about this process, it will probably save you a lot of work and heartache in the long run. Because let's face it, people don't like surprises when they're working with the government. So the more you can educate them, the easier it's going to be for you when it comes to managing your open records program. You have to have a form available so that if they don't have one, they can fill out a form, a right to know form, for requesting these records. Now, let's say for whatever reasons their request is denied. Well, you have to have the applicable appeals information posted. Now, the exception with the right to, well, let me back up here. In most cases, the appeals would come to the Office of Open Records. However, with law enforcement, depending on the basis of your denial, there is an exception where the appeal would be to the County District Attorney's Office. And we'll talk about that in more detail as we get towards the end of the presentation. Okay. Then you need to instruct all of your staff that if they receive a right to know request, it needs to be forwarded to the Arrow as soon as possible. And I say as soon as possible because there are hard deadlines built into this law with no wiggle room. And depending on the circumstances, it may be injurious to the department if there is a delay in getting the right to know request to the appropriate person. Okay, it just depends on when the clock starts ticking on these deadlines. So you want to let all your staff know that if they receive a right to know request, they can't just let it sit on a counter somewhere thinking that, okay, I'll get this downtown or I'll get this to the right person in the next day or so, because the clock may have started ticking depending on the circumstances. And then we ask that you notify us here at the Office of Open Records who your arrows are. Okay, on our website, and you'll hear me refer to this website quite a bit, there is a database of all the arrows statewide, but some of it is based on voluntary cooperation from the agencies. And we realize, people move on, they retire, they get promoted, whatever, and the arrows change. Okay, so one of the takeaways from this morning is to check our database, make sure your information is up to date. If it's not, there's a form there for you to complete. You can email it to us, we'll verify it, and we'll update the database. What happens is, number one, people can search on this database without ever contacting you. Number two, we get calls, hey, I checked with this borough's website. They don't have any information on who the Arrow is for the police department. Can you help me out? So we'll look it up for them. And finally, if we receive an appeal, if you have denied a right to know request, and the requester has decided to appeal it, we rely on the contact information in the database to send all the appeal information to. So if that's out of date, this is one of those examples where there could be a serious problem because of the tight deadlines that are built into this law. So if your information is up to date, the process will flow, more smoothly, and we can get on with the business at hand. If it's not up to date, well, then that's going to cause delays, it's going to cause problems, and it's going to be a problem for everybody at that point. All right, so let's let me check again for the chat. Here it comes. We do have a couple questions. Okay. Do you have a standard sample form available that can be adopted by the department? Yes, Chad. On our website, under right to know requests, you will find what's called the standard right to know form. And I should say this, that if you require that a right to know request be filed on a right to know form, and you have the option of not doing that, but if you require that all requests be on a form, it can be on your own form, or if someone comes in with the standard form off of our website, you must accept that, okay? And there's nothing necessarily special about that form. It's just something that we put together that we believe covers, most of the options and possibilities that could be raised when you file a right to know request. But you're more than welcome to copy that and put your own seal at the top or whatever. That's fine. Okay, another question. Does the police department need its own arrow, or can the municipality have a single administrator serve as the township's arrow for all the department? The answer is yes. And I'll put it this way, okay? If you have one administrator serving the entire jurisdiction, that's fine, okay? There's no problems with that. But if you're a police department and you have your own arrow, that's fine too. Again, just make it clear to the public who the right to know request should go to. Now there is an issue. There's a law called CREA, which we'll talk about. It's the Criminal History Records Information Act that limits access to certain records to only law enforcement personnel. Now, this has never been litigated. It's never been an issue as far as any sanctions that I'm aware of. But I have had discussions with police chiefs about if you do have an arrow covering the entire jurisdiction, okay, the administrative side, public works, as well as the police department, are you violating CREA if the arrow who's responsible for all records has access to confidential law enforcement records when in fact that arrow is not a member of the law enforcement agency, okay? I think it's a great question. I think it's one, if I were a police chief, I would be a little concerned about, but we don't have any legal basis to say you must have your own arrow, all right? It's simply something, I keep in the back of my mind as saying, okay, this is a potential problem, but until it's, it's actually litigated and the courts provide a definitive answer, I'm only saying I've had this conversation with multiple police chiefs, and we think it's an interesting issue. And we've also discussed it here in the office. But yeah, great question, John. Okay, let's move on to the next slide. There are some things that you cannot do related to the right to know law, and these are covered in section 1308. The first thing is that you can't adopt a policy or limit the number of records which a person might request, or the number of right to know requests that they file within a certain period of time. You can't say, ma'am, I'm sorry, you already filed 3 right to know requests this week, that's all we allow. If she's inclined to file a dozen right to know requests, the law allows her to do that. Also, you cannot compel a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think the reason might be, even if that reason is just to see you work harder. Okay, now I'll get on my soapbox here briefly. The majority of people who file right to know requests do it for legitimate reasons. They need a public record for whatever they're working on. And they've got a problem, and that public record is going to solve that problem. But there are a handful of people who have, for whatever reason, the relationship between the department and that person is broken down. Maybe they got a traffic ticket, maybe they just don't like the police chief, whatever reason, and they've decided they're going to be a pain in the neck by filing lots of right to know requests. Okay, Now, I've worked with the right to know law since near its inception, the better part of 10 years. And I can tell you that the solution to dealing with people like this, at least from my perspective, lies on the payment side of the right to know law. There is a misunderstanding by a lot of folks that the right to know law is free. It's not. And we're going to talk about the payment side of it briefly during this presentation. But we also do another webinar on the right to know law and payment issues, where we talk in greater detail. And, here's the thing. Most people are willing to pay a reasonable fee for the public records that they're seeking. Those people who are using right to know requests to be a pain in the neck usually are not willing to pay to be a pain in the neck. So if you can come up with a legitimate cost related to those frivolous right to know requests, the person goes away. All right, so that's all I'm going to say about this. If it's an issue for you, you can reach out to the office, or I would recommend that you participate in one of those webinars where we talk about the payment issues in detail. All right, let me check the chat. And I apologize again, this is cumbersome, but it seems to be working. And I appreciate your patience. And it has nodded. Oh, yes, it has. Now it looks like I can advance it. Okay, it's working. Yeah, great. I think it's working. Okay, I'm advancing the wrong way. That's the problem. Now everything is reversed. Sorry about talking to myself here. I'm going to try this once again and make sure that I'm doing the right thing. What a pain. Okay, yeah, it looks like we're good. All right, advance the slide. I like to describe the right to know process as an obstacle course. It creates a picture that works for me. And the start is when you receive the request, because that's when the deadlines kick in, okay? And the deadlines themselves are kind of like a time standard. You've got to get the work done within, I don't know if you're familiar with bicycle racing, for instance. I've never raced in a bike race, but I had friends who have, and there's a thing called off the back, that if you're not fast enough to make it through certain points during the race, they tell you, hey, you're done. You're off the back is what they call it. And you no longer continue during the race. And that's the aspect of these deadlines. If you don't get the work done by the appropriate deadline, you could be called off the back, meaning you lose, okay? So we don't want to do that. And then during the course, there are 2 hurdles that you have to go over. And in front of the second hurdle, there are 3 hoops that you have to get through before you can even get over the hurdle. Once you get over the hurdle, the second hurdle, you're basically saying your request is granted and we're going to give you these public records, okay? So the first hurdle, that it poses a question and we have to answer. Let me talk about the deadlines first. When you receive a right to know request, you have to provide an initial response within 5 of your business days. Now, most police departments are 24/7 operations, but a business day would be considered those days when the public can enter the office to conduct public business. So you're looking at your administrative staff if you have any. Now, a holiday would not be considered a business day. Saturday, Sunday would not be considered a business day. If there's an emergency closing due to weather, that's not a business day. So you're looking at basically a Monday through Friday operation on those days when you're open for the public's business. Now, if you're unable to provide an initial response within the 5 business days, the agency can unilaterally invoke a 30 calendar day extension. Now, calendar day is different. That does include Saturdays and Sundays. It does include holidays, and it would include any days otherwise closed for an emergency weather situation. You simply look at the calendar on what would otherwise be your 6th business day. You then count the 30 calendar days. Now, in order for the extension to be valid, some conditions need to be met. The first is that you need to invoke it within the 5 business day window. You can't wait until what would otherwise be the 6th business day and say, oh my gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, you missed that deadline. So you've done what's called a deemed denial, where you denied it by default through your failure to respond within that initial deadline. Next, you need to let the person, the requester, know in writing that you're taking the extension. And if you use it email, if they submit the right to know request by email, well, you can respond back using email. Then you need to provide a reason as to why you're taking the extension. And if you go to Section 902 of the law, it lists 6 reasons, and you simply pick those that are the most appropriate. It could be we keep these records off-site, and it's going to take us longer than 5 days to go dig through them. Or we want our solicitor to review these to make sure we're not giving out anything we're not supposed to. Or it could simply be due to manpower constraints. It's going to take us longer than 5 business days to respond to your request. Okay, but you need to let the person know why you're taking that request. And then the other deadline you need to be aware of is that if you deny the request, you let the person know their appeal rights, and typically it's they have 15 business days to make up their mind whether they're going to file an appeal or not. Okay, and we'll talk about appeals towards the end of the presentation. All right, I'm going to go through this exercise with questions again on the chat. And it looks like nothing's come up. Okay, good. Advance the slide. Okay, so we're at the first hurdle, and we have to answer the question, is it a record? Okay, now that seems pretty basic, okay? But when I tell people who are looking at a law, how do you truly understand it? I make sure they understand, don't forget about the definition section, okay? Oftentimes when you read a law, the language, is written in legalese. There's stuff that's vague. There may appear to be conflicting provisions. Oftentimes, by looking at the definition section, it can shed light on the confusion that you're otherwise experiencing. I think I may have just mixed metaphors there, but you understand. So within the right to know law, the definition section, there's a definition of a record, all right? And it goes something like this. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is et cetera, et cetera. Okay, key phrase is highlighted. Documents a transaction or activity of an agency. All right, what does that mean? Let's translate that to English. It means that a record has to be about what the agency does. Okay, its mission, the work it does day in and day out. And you're thinking, well, that seems like a no-brainer. Why would we have anything that doesn't do that? Well, think about it. Let's say I send an email to one of my colleagues. Did you hear about the restaurant that opened up downtown? Let's meet for lunch tomorrow. Okay, it has absolutely nothing to do about the Office of Open Records. Okay, under the right to know law, that email does not rise to the definition of a record. Thus, it doesn't make it over the hurdle. It's off the obstacle course. Request is denied. And you're thinking, okay, well, what if I send a text message to one of my colleagues? Did you hear about the trades that the Eagles are making for this fall? What do you think it's going to do with their chances? Or, I'm picking up a gallon of milk on the way home tonight. Okay, all fairly common communications that you would find in a typical office or work environment, but yet none of those would be considered a record under the right to know law. And like I said, if you're off the course, request is denied because it's not even a record. Okay, now let me make something clear though. Let's say that I'm at home and I'm in my family room
I'm on my personal laptop and I'm on my personal Gmail account, but I send an email to one of the admin staff here saying, hey, could you send me the filings on this particular appeal because I want to get an idea as to what the central issues are. And I send that on, okay? Now that is a record. And matter of fact, it's a public record, but it is a record, even though I sent it on my personal device, on my personal account, okay? So if you happen to be using home computers, or let's say you're using your personal cell phone, to send text messages about work-related issues, you very well could be generating public records. Now, there is nothing wrong with doing that, okay? Or I should say there's nothing illegal about using personal devices. You just need to be forewarned that those messages are discoverable under the right to know law. And the arrow could ask you for any relevant messages from your cell phone or your personal computer that are responsive to the right to know request, all right? I recommend against it, that you would have a separate department issued device, but not all departments do that. So you do the best you can here, but just be forewarned. Worst case scenario, I'm probably going to get off track here a little bit, but I met a township supervisor who received a work-related, actually it was a Facebook message involving an employee termination. That employee filed a wrongful termination lawsuit, and the township supervisor's phone was impounded as evidence for several months related to this court case. Gosh, I wouldn't want that to happen. Okay, but like I said, I'm getting a little off track here. Okay, so we've answered the question, or we should have answered the question, is it a record? All right, and let me check the chat feature. I have no questions that have come up. Okay, good. Okay. The other part of this definition, any information regardless of its physical form. Let me just run through this real quick. Obviously a paper record, but electronic records as well. I already mentioned emails, text messages, phone records. If you're using a desk phone, a landline, those phone records may in fact be discoverable under the right to know law. Who was the chief talking to? That kind of thing. Now, I should mention, when it comes to cell phone records, and emails for that matter, let's talk about deleting messages, okay? Because I prefer what's called a clean desktop on my computers. I have a tendency to go through quite frequently and delete any junk that I don't need, all my old emails and so forth. So let's say I'm using my work-related computer. We're talking specifically about emails. If I go into my, it would be my old email folder and delete them, okay? Are they gone? Well, no, they're not, okay? If this particular laptop that I'm using here, it has a wastebasket, or a recycle bin, it's called. So if I go to the recycle bin, I can find all those messages. They're still in my possession, so they're still discoverable. Now, if I clean out the recycle bin, if I delete all those messages, it's no longer on my laptop, okay? But the Office of Open Records has what's called an email server, which is something that the computer guys control. And those deleted messages can still be found on the server. So technically, we're still in possession of those emails, and any that are responsive would be included in whatever we provide to the request. Okay, so the hard drive on the email server gets full every now and then, and the IT folks come in and they clear out a certain percentage of those old expired messages. Once it's removed from the email server, at that point, it's no longer in our possession, and we're under no obligation to otherwise retrieve those messages. There's no requirement for like any sort of forensic search for otherwise deleted messages. It only goes so far as to what you can retrieve using your equipment and your personnel. You do not have to go to additional expense in order to retrieve otherwise deleted messages. Now with phone records and text messages for cell phones, little different. There, in order to conduct what's called a good faith search, you have to, at the very least, contact the cell phone provider to see whether or not they will provide the messages. Usually, they will say, we will, but you need a subpoena. Okay, well, under the right to know law, you're not required to obtain a subpoena in order to retrieve otherwise deleted messages. By simply saying, we reached out to the cell phone provider and giving, in your response, providing the documentation that they require a subpoena, that is sufficient for establishing that you conducted a good faith search. Okay, let's move on here. Security camera footage. This is an interesting one because it depends who is in control of the security camera system. Let's go back to that borough we were talking about. If the borough has a camera that covers the front entrance, if the monitor and recording equipment is controlled by someone on the administrative side, the non-law enforcement side of the borough, then the footage is discoverable under the right to know law. If, however, the monitor and the recording equipment is controlled by the police department or the law enforcement side, the right to know law does not apply. Rather, the appropriate way to get that footage is through filing an Act 22 request. Act 22 is the law that gives people access to body cam, dash cam, and security camera footage. Okay, the law happens to include that term security camera. So if it's under control of the law enforcement side, you file an Act 22 request. And that is an entirely different law that the Office of Open Records has no jurisdiction over. Now, I'm going to talk about it here in a moment because when Act 22 came out, it was basically because police departments were being inundated with right to know requests for body cam footage. So the legislature passed Act 22, but nobody had any information on what do you do? Okay, how do you get this footage? So we posted a page on our website that's still there that kind of describes Act 22. Since then, the Pennsylvania State Police have become the point agency on Act 22. I would recommend if you have any questions, reach out to the state police. But I do want to talk about it here on the next slide. Then we have social media. This would be, if you have a website, if you have a Facebook page or whatever. The point being, and just real quickly here, if you're using social media, which I think is great, just beware that you are more than likely generating public records when you generate a social media post. However, there is a provision within the right to know law that says if someone requests a record that is already online, your obligation, the agency's obligation, is simply to say, this is on our website, here's the link. Let's talk about Act 22. Oh, I need to check the chat. Bear with me. Okay, no questions. Good. All right. So, dash and body cam footage. Okay, Act 22. If someone is seeking footage from a dash, body cam, or a security camera, controlled by the police department. They file an Act 22 request. No involvement with the right to know law or the Office of Open Records whatsoever. The person must file the request within 60 days of the video being generated. Okay, so if it's been expunged, for whatever reason, that person is out of luck after 60 days. The police department now has 60 days in which to provide 30 days in which to provide a response. Okay, and something that's really different is that the police department can charge reasonable fees. And that includes labor, whatever they deem as reasonable. And then any appeals, again, would not come to the Office of Open Records. It goes straight to the courts. So if the denial would be from a local police department, it would go to your county court of common pleas. If it's with the state police, it would go to the Pennsylvania Commonwealth Court. But the big point that I want to make here, in addition to just making you aware of the difference, is that the Office of Open Records can't help you out. Okay, what we'll basically do is tell you need to go to the police department, and we probably get 2 or 3 calls a day with requests for video footage, and that's our response. You have to contact the police department directly. Okay, let me advance. I'm not going to check this time around. Okay, I think I need to go back here. Uh-oh. Whatever reason, this is not advancing. Let me go try this again and see what's the problem is here. Okay, I'm having some technical issues. My laptop is advancing, but oh man, what's going on? Okay, question has come up from Chief T. Does this also cover security camera footage of the complex? It's going to come down to what the footage actually covers. Okay, does it represent a transaction or activity of the agency? If all it's showing is like the traffic out front on the road, chances are you could argue that has nothing to do with our department. If, however, it shows like people coming in and out of the entrance, who had appointments that day or whatever, what time did so-and-so show up for work, that could possibly be considered a public record. But again, you've got a lot of other issues to, to flesh out as to whether or not you would not be releasing something that could possibly, create, a public safety issue. So there's a lot to consider, but yeah, good question. All right, I'm still dealing with a technical issue here. Why isn't this advancing? Again, it's advancing on my laptop, but not the main screen here. So I think you're probably not seeing that. Try this. What's going on? Okay, I think I've lost some sort of connectivity. Again, I'm going to go out. Back in. Folks, we have quite a mess here. I'm not sure what's going on. The system is crashing. Our new fancy system. I'm trying to reestablish the video. See if it advances. Yes, okay, we're back online here. Okay, thank you for your patience. I just needed to reboot it. Let me get the chat back up. Okay, couple questions. Okay, Nicole. Let's see what we got here. Okay, Nicole, since it's off topic, we'll come back to it, and it's a rather long, and I'm running behind here, so I'll come back to your question. Okay, so that's it for Act 22. Now we come up to the second hurdle, and here we have to answer the question, is it a public record? Okay, now remember, the first hurdle was, is it a record? Now we have to ask, is it a public record, which is different, okay? Remember, there are 3 hoops in front of the hurdle that we have to go through. So we have to answer some questions. First, do any exemptions apply? And if so, are we going to invoke them? All right, now an exemption, what the heck is that? Well, within the right to know law, it's section 708B, there are 30 exemptions. And these are definitions of records that can be withheld by the agency if the record that is being requested falls within that definition. For law enforcement, we're going to talk specifically about 3 exemptions, okay, that are really important. But, you know, for instance, there's one exemption that says, if by releasing this record, we would put somebody in harm's way, you can withhold it. There's another one that says any information about a minor, you can withhold. There's one, any health records, okay, employee health records, you don't give those out, that kind of stuff. Okay, then the second hurdle, we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? And then the third one is the record protected by privilege. Now let me advance the slide here real quick because I forget what the next one is. Okay, now my laptop's not even advancing. What is going on here? Bear with me. Ah, there we go. Okay, let me go back to this slide and go through these. Okay, so I want to answer the second one, the question. Federal or state statutes. Now, I talked about the one that's most important. If you're with law enforcement and you're not familiar with CRIA, the Criminal History Records Information Act, well, then you should be, okay? Because CRIA is a statute that essentially identifies a body of records that most police departments have access to and legally can only share with other certified law enforcement agencies. Now, here's an interesting point. We talked about Act 22. Under Act 22, the definition of a law enforcement agency is much broader than the definition in CRIA, okay? For instance, under Act 22, believe it or not, a school district could be considered a law enforcement agency because they sometimes have resource officers and any video within their possession may be considered a public record. It just depends on the circumstances. Under CRIA, clearly a school district would not be considered a law enforcement agency. So remember what I said about the definition section? Here's a good example where the definition under Act 22 of a law enforcement agency is significantly different than the definition of an act of a law enforcement agency under CREA. Okay, so CREA is an example of a state statute that says you don't give out these records. Under the right to know law, an agency has the discretion to give out a record if they want to. Under CREA, that discretion is removed. And if there is another law that says these records are confidential, that trumps the right to know law. Okay, they take precedent over any discretion the right to know law would otherwise provide you. And you can get a summary of this by reading the right to know law, going to section 306. Federal laws, for instance, I mentioned health-related records. Well, you've got the alphabet soup of federal health-related laws like HIPAA, ADA, FMLA, and so forth, all of which make it illegal to give out any health-related information on a public employee. So you would want to make sure that there are no other laws making these records confidential. And you remember what I said, you've got these powerful tools available to withhold records if a red flag goes up. Well, here are some examples, okay. Under Homeland Security, you're going to find laws that make various records confidential. And you can use those as your legal basis for withholding a record in response to a right to know request. Okay, then the third hoop that we need to get through is the record protected by privilege? Typically what we're talking about here is attorney-client privilege. The way this works is that any sensitive information exchanged between an attorney and their client. For our example, we're talking about a solicitor and the public officials or senior management of your agency, whether you be city, township, borough, or whatever, okay, is protected, probably protected by attorney-client privilege. If you have any questions about that, if you're in doubt, reach out to your solicitor and ask them, should we withhold this based on attorney-client privilege? You can also find the reference within the right to know law under section 305, because it basically says if the record is protected by attorney-client privilege, then it's not a public record, okay? Attorney-client privilege is based on the rules of evidence in Pennsylvania, which is essentially a statute, okay? So it all kind of fits together. All right, let me get a sip of coffee here. Let me check the chat features since things seem to be working a little better now. But let me just double check. It has advanced. And there are no questions. Okay, let me advance the slide. The exemptions, okay, these are the exemptions within the right to know law that anyone dealing with the right to know law on behalf of a police department should be familiar with. The first is the one most commonly used, invoked, section 708B16. It involves any record that is critical to a criminal investigation. Meaning, and this does not have to be an active investigation, okay? It can be a 20-year-old cold case. There's no statute of limitations on this, all right? But if the record is critical to that investigation and you deem the record, you don't want to release the record, you can invoke 708B16 as your legal basis for withholding that record from public disclosure. Now, it does not cover what's called blotter information. Some departments, they're not even familiar with that term anymore. But if your department maintains, whether manually or electronically, any sort of shift diary, an incident log, that would, in essence, summarize, we sent a unit at 3:30 a.m. to this particular address to investigate a noise complaint, okay? That is considered public, okay? But anything in greater detail, like the incident report, is not public, okay? Let me repeat that. Police incident reports
are not considered public records because there is a court case that goes back, I think, to 2010, Pennsylvania State Police versus the Office of Open Records, where the Pennsylvania Commonwealth Court, Justice McCulloch, wrote, because incident reports are inherently investigatory in nature, the B16 exemption applies, therefore they are not public records. Okay, now, many departments will release incident reports, but they'll have the sensitive information deleted or redacted in some way. Okay, it's up to you. It's up to the department as to how they choose to handle that. Then we come up to 708B17. This is where you determine that the records are part of a non-criminal investigation. Okay, well, what would be a non-criminal? Let's say that you are a small department in a borough where there is no codes enforcement office. Well, someone files a complaint or someone calls in complaining about their neighbor's yard. Okay, they're saying, you know, this is a real mess and I want someone to look into this. Guess who gets sent? Yeah, the police department. Well, there's no obvious criminal activity. It's just that the yard's a mess. So you go down, you investigate, and maybe you file some sort of report. Okay, and that report might have the person who called with the complaint. Well, you can withhold those records. Oh, and then what happens is the person whose yard was investigated gets in a huff and they call in or file a right to know request. I want to know who complained about my yard. All right, you know, this is nothing new, I'm sure. So you can withhold any records of that investigation under B17 as a non-criminal investigation. Okay. Another example might be a suicide. Okay. Department gets called to the scene of what, you know, an apparent suicide. It's obvious from looking at the scene that there's no criminal activity. The person left a note, et cetera, et cetera. And then someone files, you know, someone who's curious files a right to know request where you can withhold anything, you know, that was part of that investigation under B17. And then finally, 708B18. These would cover the recordings of any activity with your county 911 center, or for that matter, any radio dispatch. And it's very black and white. The exemption is written quite tightly where you're just not going to get those records. Okay, someone files a right to know request for a copy of the recording of someone calling in to report a crime. Well, B18 would cover that. Now you're thinking, okay, well, I've heard these recordings through the news media. Well, the EMA, the County Emergency Management Administrator, can release these recordings at his discretion if he believes it's in the public interest to do so. But otherwise, they can be withheld by invoking 708B18 as your legal basis for not releasing these particular records. Okay, so that covers these. Like I said, these are the three big ones that law enforcement typically runs up against and would use as tools under the right to know law for withholding records. Okay, let me check the chat. Okay, question popped up. 708B17 denial that the person is now appealing. How can they appeal that? Well, Valerie, if the person disagrees with your basis for denying the request, if they think that the record still should be public, they have the right to appeal. Okay, it's just like any court case. They may not win that court case, but you know they have a right to seek it. It's their appeal rights, and typically, and you know, I'm getting ahead of myself, but let's say that the Office of Open Records then issues a final determination on that appeal that's in your favor, that says you did the right thing by withholding the record. That person can appeal our decision up to the next higher court. Okay, it's our right it's our right as citizens in the due process that we are afforded to be heard in a court of law, and we can appeal it all the way up to the Pennsylvania Supreme Court. Okay,
Doesn't mean they'll win, but they can appeal it. Okay, good question. Let's move on. Yeah, let's talk about appeals. I mentioned this earlier. With all of the 30 exemptions, if you use one of those as your, or for that matter, if you refer to another law in meeting your legal obligation to deny a request, the person has the right to file an appeal within 15 business days. Typically, they would file it with the Office of Open Records. However, here is the one exception with filing appeals. If your law enforcement agency used B16, if you said, this record is part of a criminal investigation, therefore we're denying your request under 708 B16, the appeal does not come to the Office of Open Records. It should go to your county court, or I'm sorry, your county district attorney. That is the appeal office on the local level. And your denial letter should reflect that when you outline what the person's appeal rights are. You have 15 business days to file an appeal with the county district attorney's office. The DA will have, either a deputy or an assistant DA functioning as the appeals officer. Those decisions from the counties you can find on our website. Okay, you can go in and see how your county DA has ruled on previous B16 cases. All other appeals, though, whether it uses another exemption or another law as the basis for the denial, would come to the Office of Open Records. Okay, let's talk about costs. Okay, remember I mentioned about how important costs are. In a nutshell, if you're providing hard copies, you can charge up to 25 cents a page for 8.5 by 11 single-sided black and white. Electronic records like emails, text messages, and so forth, there's no charge for them. Okay, everything else would be actual costs, like postage. If you have to mail something out, you can charge for whatever postage you're paying to get those records to the person who has requested them. You cannot charge for labor. You can't charge for redaction. Redaction is where you've decided, okay, this is a public record, but there's some sensitive piece of data, like a social security number, maybe a home phone number, maybe a personal email address, that we're gonna black that out, or we're gonna white it out, okay? So I'm gonna charge you an extra 10 bucks, because I have to take the time to white it out. No, you can't do that. You cannot charge for redaction under most circumstances under the right to know law. And then if there are any other legislative charges, they take precedent. They trump the right to know law. Right to know law has a fee schedule posted on our website that details the specific things that you can charge for. But if there is another law that says you can charge X number of dollars for a record that we're releasing, that takes precedent. Accident reports are a good example. Someone, they get in an accident, it's investigated by your department, they file an insurance claim, the insurance company says, well, we need a copy of the accident report. So they turn around, file a right to know request for a copy of the accident report from your department. Access to accident reports isn't governed by the right to know law. It's governed by the Pennsylvania Motor Vehicle Code. And you go to the appropriate provision of the Motor Vehicle Code, and it says you can charge $15 for an accident report. Okay, that's a lot more than that 25 cents a page. So you provide the accident report along with the invoice for the 15 bucks, or you wait for the 15 bucks and then provide the accident report. There are other laws that also have their own fee schedules, so it helps to be aware of that. Now, remember when I said police incident reports are not public records. The fee schedule for the right to know law only covers public records. So connect the dots. If you get a request for an incident report and you've decided you're going to release it, since it's not a public record, you can come up with your own fee schedule for any reasonable charge related to that incident report. Okay, you see how that works. The fee schedule only applies to public records. If it's not a public record, you can come up with any charge that you deem appropriate as long as it's not prohibited by another law. Okay. All right, let me check the chat. Really hope this works better next time. This is something new that we encountered. Yeah, some questions have come up. Are appeals under 708B16 still considered legal proceedings like the ones the OR are? That's going to vary dependent on the district attorney. Okay. And the point, it's a very good question, because when it comes to appeals, the Office of Open Records functions like a court. The Supreme Court of Pennsylvania has identified us as an independent quasi-judicial tribunal, meaning we are a court. They have not said that about district attorneys' offices. However, most DAs, because they're attorneys, they are aware of a person's due process rights, and they should be giving everybody the opportunity to weigh in on the appeal. I'll be honest with you, I am not intimately familiar with how all 67 counties operate. Some are a little different than others. And honestly, I've never looked into specifically at like how any one county, how they run their appeals process. But I think that's a great question. At the end of the day, they are legally bound to provide the requester with due process. Okay, so if you can argue that that opportunity wasn't afforded, then you can appeal those decisions to the county court and take it from there. Are there template letters available for denials, appeals, and so forth? Well, they would be available for right to know denials. Two resources available to you. First, there is the Arrow Handbook, which is on the website, 78 pages. That handbook includes a lot of templates, including for denial letters. The second resource is the Police Department Handbook, which kind of summarizes what we've been talking about here today. That may or may not include some sample language. You are not going to find templates for denials of appeals, because you shouldn't be denying appeals, our office is, unless, I'm assuming, maybe you're from a district attorney's office. If that's the case, great. I would suggest reaching out to our office for any guidance that you're seeking on how to respond to denials for appeals. And we can get you steered in the right direction there. Our office has close to 24 appeals officers, and our senior staff can certainly get your office up to speed on how to respond to appeals that might be received. DD if you're from a district attorney's office. Okay, another question. How specific does a right to know request need to be? Oh my goodness, what a question that is. Recent request looking for any and all police department records from police department involving person XXS is too vague for me to have any idea what they're actually looking for. Okay, yeah, Brian, it's going to be on a case-by-case basis. We actually do a webinar probably once every 6 months. Our Deputy Executive Director, Nathan Byerly, has a really good presentation on specificity. I'll just say, on the surface, when someone uses that term any and all, it does raise a red flag as far as whether it's specific enough. The criteria that Nathan would bring is, and this doesn't apply every time, but you need a subject, you need a time frame, and you need basically a description of the type of record that you're looking for, like an email or a report or text messages or the like. Okay, and in most cases that's required. Okay, now there are the exceptions. Like there may be an instance where I don't need a time frame, where it's applied, or the subject is, the other criteria is narrow enough, like maybe the date range, that I don't even need a subject, that I could ask any and all within specific dates, okay? It's all very subjective. Specificity, it's a very subjective topic, and I don't think it's ever going to go away. So I can't provide you with a definitive answer. But if you're suspecting that well, I'll take you to a provision of the law, Section 701, that I rely on, where basically it says that the request must be specific enough so that the person reading the request, the arrow, can identify the responsive records. If you can't make heads or tails of what the person is asking for, or if you are unable to identify the responsive records, then it's obvious that the request is not specific enough. But there is case law that goes into this deeper, and we still are seeing case law on the issue of specificity. And I think I don't think it's ever going to go away, where the courts are answering the question, is this right to know request specific enough? But at face value, like I said, when you see that term any and all, in my book, that raises a red flag. Okay. That's a good question. I wish I could provide you with a better answer. All right, I'm going to move on to the next slide. And this is the end of the presentation. So get your questions in now. Let me just double check here. I'm going to go in and out of the chat. And I didn't forget about that one that I'm going to go back to here in a moment. Okay, some other questions have come up. Okay, is the event tomorrow in Carlisle the same as this presentation? I apologize. I'm not sure what's going on in Carlisle tomorrow. Okay, I'm not an employee. I'm a consultant who comes in just to do these webinars. It may be possible. I would check with whoever is hosting the event. I'm not presenting it. Okay. Watch for Nathan's webinar in the future. That is it's a very good webinar. Okay, Nicole, I promise you I'm going to go back to it. I have received a message that someone may file a right to know request for an individual officer's past and future scheduled shifts. Is a police department officer's schedule deniable? In most cases, it is not, Mark, unless by releasing that schedule, you can show it represents a possible threat to public safety. We had at least one department that was able to deny individual schedules because there was a period during the day when shift force was significantly weaker than it would normally be. So they were able to make the case that by releasing these schedules, it would potentially represent a threat to public safety. Okay, but it's not, remember, you can't create a hypothetical. You've got to show an actual weakness, an actual threat to do so. And maybe your officer, maybe it's someone who's working undercover. Maybe, I don't know. It's really fact specific, but in most cases, a simple work schedule would be considered a public record for that matter. Okay, good question. All right, I'm going to try and scroll back to Nicole's question, see if it will let me do that. Yeah. Okay, where'd it go? Here we are. Oh, it keeps defaulting back to the end of the chat. And I think it happens every time somebody logs off. This is a mess. Yeah, Nicole, I'm going to keep trying here. Okay. Camera footage, hoping clarification. Resident requesting complete bank statements. Oh, okay. Yeah, bank statements are tough. Specifically under the right to know law, there is nothing that makes bank statements confidential. However, I'm going to say, you know, there's a concern about account numbers and so forth, and the possibility of somebody doing something bad if they have account information. The other issue is, do you truly have these bank statements in your possession? If you have to go into the bank's website in order to get these otherwise secure records, you can make the argument that they're not in your possession. Unfortunately, this is something that is not yet to be litigated. If you have a genuine concern over the release of account information, maybe you want to take a shot at denying access to these statements because of the fear of them being misused. And your solicitor would have to make that case, showing that, you know, it is a true and credible threat. It can't be a hypothetical. Okay, the statement includes a reconciliation page, which is usually page 2 as we receive it. They are disputing that we should not have included that page. We checked with other boroughs and they agreed that the complete statement is all pages. Okay, well, it depends on who's disputing it. Okay, if you release the page, then it's no harm, no foul. If, however, you know, your solicitor or your senior management is saying you shouldn't have released it, you know, maybe next time withhold it, then the person has the option of appealing it and we'll sort it out, okay, through the appeal process. If you don't want to go through the expense and the time of an appeal, then you can release the record as you see fit. But if you're being told next time not to release it, maybe you want to do that and then see if it gets appealed, and we'll come up with a definitive answer for you. That's how I would approach it. But when it comes to bank statements, that is a touchy area. Unfortunately, there's no definitive language either in the right to know law or in subsequent case law that deals with it. I'd like to see that language at some point, but you know, I'm not in charge, so it doesn't really matter. But you know, there are more and more, we're getting these questions, should we be releasing this bank account information? And I would be concerned about it. Okay. Let me see now. I need to go back and check the chat feature before we wrap up for the day to see if we have any more questions. Okay. Okay, Nicole, yeah, I see. The requester is disputing it. Oh, okay, so it comes down to, all right, you have to answer the question. Is page 2 part of what they asked for? Okay, if it's not what they asked for, then you withhold it. Okay, they shouldn't have to pay for that. If, however, by reading their right to know request, they're asking for statements, page 2 is part of the statement, that's what's provided by the bank, then I would argue that it's appropriate to provide page 2. Next time when she files a request, if she doesn't want page 2, then she can say that in the request. But you know, otherwise, it's one of those issues, one of those rare issues where you would just apply common sense. She asked for the statement, page 2 is part of the statement, we're providing page 2, and by the way, you got to pay for page 2. That's how I would approach it. Next time, if she doesn't want page 2, she can tell you that. And then you withhold it, she doesn't pay for it, problem solved. Okay, under the right to know law, if a person believes they're being charged more than what they believe is appropriate, they can appeal it, okay? We have dealt with appeals over payment disputes since day one of the right to know law. So they can file an appeal and we'll sort it out and we'll take it from there. But I think, you know, well, I shouldn't say it, but it sounds like you did the right thing. All right, hopefully, Nicole, that gets you steered in the right direction. All right, I'm going to check one last time for see whether any chats have come in. Otherwise, I want to thank everybody. Yeah, I want to thank everybody for your questions today. I apologize for the technical issues with things freezing up, and I don't know why the chat is not advancing. It's a new problem, but we'll try and sort it out. But we'll be back in 2 weeks, where I think we're going to be talking about the Sunshine Act. But, you know, enjoy this warmer weather that we're having. Stay safe. Thank you for everything you do out there, law enforcement folks. And we'll see you again in 2 weeks. I'm signing off now. Take care.